Okay, we're back for part 2 of our Chapter 8 lecture on interrogations and confessions. And if you recall, we left off talking about due process, and we talked a little bit about fundamental fairness. We understand that the aim of the voluntariness test is not only to exclude false confessions, but also to ensure that fundamental fairness that we were talking about in the methods used in obtaining confessions. We talked a little bit about some police methods and a little bit about involuntary confessions. And I wanted to finish up before we move on and talk about just voluntariness. What does that really mean? Well, in the eyes of the Supreme Court, they have held that to be admissible into evidence, a confession must be made freely, voluntarily, and without any type of compulsion or inducement of any sort. And a confession that violates due process and is excluded from evidence that involves either coercion or basically violates the will to resist, meaning that that coercion overcomes the abilities, a person's ability to resist, if you will. So with that said, let's look at some of the purposes of this voluntariness test. Why do we really have it? So the voluntariness test, again, is designed to achieve 4 different purposes. And the first one would be trustworthiness. And basically confessions that result from physical or psychological coercion run the risk that a defendant confess to avoid or stop some type of abuse, and statements that are made under these types of threats are typically unreliable, meaning that they may be false. Fundamental fairness, well, the use of an involuntary confession against a defendant is fundamentally unfair and compromises the integrity of the courtroom. Offensive police methods, well, confessions in violation of the due process clause are typically the product of police tactics that are offensive to, let's say, fundamental values. And then finally, free will or rational choice. And here, confessions violate due process if they are the product of, let's say, drugs administered by the police, or of a suspect's psychological disabilities, and they don't result from free will or rational choice. And we've looked at a couple of different areas there as well. So, in addition, again, the Supreme Court has held to be admissible into evidence a confession must be made freely, voluntarily, and without compulsion. And again, a confession violates the due process, or a confession violates due process and is excluded from evidence if it involves those 2 things we talked about, coercion and a will to resist. And remember, the prosecution bears the burden of establishing voluntariness, meaning did the person voluntarily confess? And this voluntariness is based on the preponderance of the evidence. And surrounding that, the courts will consider a number of different factors. So we've seen examples of coercive conduct in the cases that we've talked about, but now we're going to kind of look at, well, how do courts determine whether there was coercion or whether coercion overcame somebody's will to resist. And again, it's based on a totality of the circumstances. And the courts, again, are going to look at a number of factors that formulate that totality. So first would be physical abuse, which would be something like threats of abuse by police or something similar. Psychological abuse or manipulation. Threats, rewards, or trickery inducing a suspect to confess. Interrogation. Remember the length and the time and the place of questioning and the number of police officers. So it doesn't mean that you can't interrogate. It just means that having maybe 10 people in an interview room with one suspect might be too many, and therefore it might look a little bit overwhelming, right? Does that kind of make sense? 28 hours to interrogate somebody. Is that a little bit long? So all of these are considered issues that we need to look at. The next would be an attorney. A refusal to permit a person to consult with an attorney, friends, or family. The defendant themselves, how about their age or their education level or their mental or emotional development? That could play into this. And even what we call procedural regularity, which is a failure by the police to follow the proper legal procedures, like advising someone of their Miranda warning. And then finally, necessity. The police are provided greater flexibility in interrogations when attempting to solve a crime or exonerate a defendant when they already possess evidence of a defendant's guilt. So again, these are things that the courts will consider, and they'll look at a number of factors on determining whether or not something is in fact voluntary. We talked about the voluntariness. We talked about the Spano versus New York case, and this case illustrates the totality of circumstance approach in determining whether or not a confession is in fact voluntary. And I'll let you take the time to look up that case. Never mind. I think I'm going to go a little bit further. I didn't know that I put this slide in here, but hey, okay. So in the Spano versus New York case, again, it illustrates the totality of circumstance. And in Spano, the U.S. Supreme Court held that the defendant's will was basically overborne by official pressure and fatigue and sympathy that was falsely aroused, if you will. And the court's conclusion was based on several different factors. Psychological abuse, meaning the police basically had a childhood friend come in and play on the person's sympathy. Interrogation, the defendant was questioned for 8 hours at night by 14 officers, and his confession was written down by a skilled prosecutor. He didn't write his own statement down. The attorney, the police disregarded the defendant's refusal to speak on the advice of counsel and ignored his request to contact a lawyer. The defendant himself was 25 years old, but never had before been subjected to custodial arrest or interrogation. He had not even completed high school, and he did have a psychological disability. And then we talked about the word procedural irregularity. The police failed to immediately bring the defendant before a judge and instead subjected him to interrogation. And then finally, necessity. The police already had eyewitnesses to the shooting case and were engaged in securing the evidence required to convict the defendant rather than identifying the individual responsible for the crime. So hopefully all of those make sense, and that's the Spano versus New York case. There are some criticisms that we need to kind of keep in mind. And the due process test is subject to a couple of criticisms. The first would be the standards, because there really are no clear guidelines for the police concerning what conduct is permissible and what conduct is not. When you talk about evidence, the defendant and the police may offer radically different versions of the defendant's treatment during interrogation, and judges find it difficult to sometimes reconstruct what really occurred. And then finally, litigation. The lack of, definite standards encourages legal appeals and increases the caseloads of everybody involved in the court system. So there's a lot of issues that kind of come out here. But under this case, Mallory versus United States, the police may not arrest and interrogate a defendant and then decide whether there is probable cause to charge him with the crime. And this rule focuses on the length of delay between an arrest and a suspect's initial appearance before a judge. The courts generally consider unreasonable delay to be one of several factors to be considered, again, in evaluating the voluntariness of a defendant's confession. In another case, the Escobedo versus Illinois, this extended the Sixth Amendment right to an attorney to the period prior to an indictment. And an indictment, which I think we already know, comes from a grand jury. And this was the point in which most confessions were elicited. And a failure to provide access to an attorney at this stage would render legal representation at trial meaningless. And any competent attorney undoubtedly would have told their client not to talk to the police. So again, these are important cases for us to kind of look at. Mallory versus Hogan is another case. The Fifth Amendment's prohibition to compulsory self-incrimination was incorporated into the 14th Amendment and is applicable against the states. The privilege against self-incrimination is violated only when incriminating information is used against a person in a legal proceeding. And the requirement that one may not be compelled to be a witness against themselves is satisfied when required to answer questions asked by the government. So let's take a quick look at the legal equation when we talk about self-incrimination. So here we have the self-incrimination, we have the compulsion, the criminal case, the witness against yourself, and then the testimonial evidence. So what now is Miranda versus Arizona? Because now we're going to kind of get down to a couple of, we talked about the right against self-incrimination a little bit, but this is one of the bigger cases. So in 1966, in Miranda versus Arizona, a 5-judge majority of the U.S. Supreme Court held that the prosecution may not use statements stemming from the custodial interrogation absent procedural safeguards to protect a defendant's Fifth Amendment privilege against self-incrimination. And the court majority concluded that absent a 3-part Miranda warning, the inherently coercive pressures of police interrogation had been proven to overwhelm a person's capacity to exercise their right against self-incrimination, and no confession given under these conditions can truly be the product of an individual's free choice. So Miranda, as we have seen, supplements the due process voluntariness test by requiring that the police read a suspect subjected to 2 things: custody and interrogation, or custodial interrogation, their Miranda warning. And I have a photocopy of a Miranda card, and you can see that it has more than 3 parts, but it talks about you have the right to remain silent. And in this Miranda card, it asks the person if they understand. Anything you say may be used against you in a court of law. Do you understand you have the right to the presence of an attorney before and during any questioning, do you understand? And if you cannot afford to hire an attorney, one will be appointed free of charge before questioning if you request one or you want. Do you understand? So this is the case. I have a couple of really good videos on the Miranda versus Arizona decision, and I will let you look at those at your leisure. The case is actually located on page 279 in your textbook, and I would highly suggest that you really understand and read that case. And before you begin to read the Miranda decision, you may find it interesting to learn about Ernesto Miranda, the individual whose name is attached to one of the most important U.S. Supreme Court decisions in recent history. Miranda was in constant trouble as a young man and committed a felony car theft in 1954 in the 8th grade, and this arrest was followed by a string of convictions and brief detentions for burglary, attempted rape and assault and curfew, and peeping Tom activities and more car thefts. So he had a lot of issues relating to the criminal justice system. But take a look at some of that. Read a little bit about him before you actually look at the case. And looking at the Fifth Amendment, here's the legal equation to kind of help you out. When we talk about the Fifth Amendment, the privilege against police interrogation, well, self-incrimination, it talks here about the prosecution may not use statements stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards. That's the Miranda. Custodial interrogation is the questioning initiated by police after someone's been taken into custody or deprived of their freedom. And prior to any questions, the suspect must clearly be informed that he or she has the right to remain silent, that any statement that they make may be used as evidence against them, and that they have the right to the presence of an attorney. So again, it's that three-part thing. So when is Miranda kind of triggered? Well, Miranda warnings are triggered, again, when a person is in custody and interrogated, and I can't say this enough, both of those pieces need to be in place for you to be required to Mirandize someone. And again, the Miranda decision defines custodial interrogation as questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of their freedom of action in any significant way. Okay, so what is custodial interrogation then? Well, Miranda warnings need not be given to an individual who voluntarily comes to the police station and wishes to confess to a crime, or to a person who voluntarily calls the police to offer a confession or other statement. Now, can you read the Miranda rights? Absolutely. Is it a safeguard that you would probably be smarter to do? Yeah, probably. Now, the objective test for custodial interrogation, and you've heard this phrase before, is what we call totality of the circumstances. You've heard that before, and that really is a great way for the courts to look at things, because sometimes you need to look at the big picture, if that makes any sense. So custody is based on whether in the totality of the circumstances a reasonable person would believe that he or she is subjected to a formal arrest or to police custody to a degree associated with formal arrest. So again, the challenge is, for everyone really is to determine at what point, short of being told that they are under custodial arrest, is an individual exposed to these bases, if you will? When do they fall into that category, short of being told? Well, the courts will typically look at, again, or ask whether a reasonable person would be free to leave. And some of the factors that are considered in evaluating this, again, are the totality of circumstances. But judges will look at a bunch of different factors. Now remember, no single factor is crucial in determining whether a person would believe that they are subject to custodial interrogation, meaning not free to leave. But the factors to be considered would be the number of officers, whether the officer tells the person they are free to leave or not, the length and intensity of the questioning, whether the officer uses any type of physical force, whether the stop is in public or private, the location of the interrogation, whether a reasonable person believes the stop would be brief or result in an arrest. The person is familiar or unfamiliar with the surroundings. And then finally, whether the person is permitted to leave following the interrogation. So I have a couple pictures of just, interrogations. And in this one here, this person is basically, you can see he is secured to this. So when you look at this, do you think that he's free to leave? So the officer probably doesn't have to tell him that he is like in custody or he's not free to leave. How about in a dark room? I know this is TV, but an interrogation room where you're by yourself. Okay, do you feel like you're free to leave in that particular situation? So again, we'll look at the legal equations and we can look at custody and even the functional equivalent. Let me back up here. Okay, so here's the custody, which is custodial arrest or functional equivalent, and here is the functional equivalent. A reasonable person, totality of circumstances, would believe that he or she is in police custody, and is either free to leave or not. All right, so again, it's a totality of circumstances type thing. All right, so what are some, with that, all of that being said, are there some circumstances or narrow exceptions to Miranda? And that's something that typically comes up every once in a while. Like, do I always have to read somebody their Miranda rights, or is there some type of exception to this? And there actually is. So there is a narrow exception for questioning that requires questions to be directed at public safety rather than guilt or innocence. And in the case New York versus Quarles, the Supreme Court recognized a public safety exception to Miranda. And this exception permits the police to ask questions reasonably prompted by a concern with public safety without first advising the individual of their Miranda rights. And the Supreme Court explained that a reasonable concern with the safety of the police or the public outweighs the interest in protecting a person's rights against self-incrimination. Now, it's a very narrow exception, and again, the questions need to be directed at public safety. So an example could be if you're in foot pursuit and someone throws a gun, and then you finally catch up to them, and now they don't have the gun, and maybe you saw them throw it. And now, or maybe you didn't see them throw it, and now you have to ask them, where'd you throw the gun? Because couldn't they have thrown it in the backyard and some kid will pick it up and maybe shoot themselves or someone else? So again, but the narrow exception follows these 4 steps. The first is reasonableness, meaning protect the public. There must be a reasonable need to protect the public. Next is threat, which means that there is a reasonable belief that the threat is imminent or could occur quickly. The questions themselves must be prompted by a reasonable concern for public safety and directed at public safety, not guilt or innocence. Not did you do the robbery, but more like where did you throw the gun? And you can see the difference. And then finally, coercion. The statements may not be the product of police compulsion that overcomes the suspect's will to resist. So again, you can see here there are some very narrow exceptions. And here's some photos of examples of, maybe somebody throwing evidence out of a window. That's actually a bank robbery where they're throwing money out. Or somebody runs and throws a firearm and the police are asking where it is so they can find it. And maybe they bring in a canine, but they may want to ask the suspect what happened to the weapon and where did it go. So this is the legal equation when we talk about the public safety exception. The need to protect the police or the public, the belief that the threat is imminent, questions directed at public safety, and again, no coercion. A little bit more on Miranda. The police must inform individuals of the right to remain silent, that anything they say may be used against them, and of their right to an attorney to be retained or appointed. These warnings convey the essential information to the suspect. Not necessarily, understand, not the exact words. You don't have to use the exact words, but you must clearly inform the suspect. So the courts have provided some broad guidance on how the police are to recite the Miranda warning, but it is a flexible formula. And the test is whether the warnings viewed in their totality convey the information, convey the three parts. So my question to you is, why do you think that we have those cards, those Miranda cards? The reason is that if you read that card to a suspect and you use it all the time, if you were to go to court and the defense attorney would say, "Officer, did you read my client their Miranda rights?" And you say, "Well, yes, sir, I did." And the defense attorney says, "Well, what did you read him? Recite what you read him." Now most people could memorize it, but sometimes you might get nervous. So you could reply, if you do it by the card, "I read the individual his rights per a Miranda card that I carry in my pocket." And the defense might go, "Do you have that card here today?" "Why, yes, I do." And then you could read the card. You see how much easier that is? So that's the reason that we have a card, so things stay specific. But as noted, it doesn't have to be exact every single time, but it does need to have the three parts. Okay. What about invoking Miranda? Meaning, I want to invoke Miranda and I don't want to say anything. So there's a case in your textbook, Davis versus United States. And this case talks about an individual intending to assert their rights to have counsel present must actually articulate it sufficiently clear that a reasonable police officer in the same circumstances would understand the statement to be a request for an attorney, meaning invoking Miranda. I don't want to say anything. So suspects invoking their right to silence must do so in a clear and unambiguous fashion. So, you have to be able to show that it was clear. Well, what about a head shake? Or what about this? I read you your rights and you say, "Uh-huh." Is that clear? Is a head shake or a nod clear? I'll let you kind of stew on that, and we'll kind of move on. But the Davis case is one that talks about the fact that they need to invoke. If they want to invoke their rights, it needs to be done clearly. And here's the, let me go back. I kind of went through that quick. So the waiver, again, does need to be voluntary, and you need to do it voluntarily, knowingly, and intelligently to do a waiver, but it needs to be clear. An affirmative statement. So, we have to understand an affirmative statement, again, and it's based on the totality of circumstances. So there's also a thing out there called question first and warn later. And we're going to talk about that now because it's important for us to understand. So this is a case, Elstad versus Oregon. And here, the unlawful character of a suspect's first voluntary confession does not automatically taint a second voluntary confession. So a suspect who has once responded to unwarned yet uncoercive questioning is not thereby disabled from waiving their rights and confessing after he has been provided with his Miranda warnings. The Miranda warnings kind of cured the original taint, if you will, of the initial confession. And warning a suspect that a suspect's first confession was inadmissible is neither practical nor constitutionally necessary. So this is an interesting case. So again, here's the legal equation to kind of look at. The next couple of cases to look at, and then we're going to talk about a waiver a little bit more, would be Michigan versus Mosley. This is where the legal test for whether a statement obtained after a person in custody decides to remain silent depends on whether his or her right to silence was scrupulously honored. The critical consideration here is whether the police respected the suspect's right to cut off any type of questioning. And then there's a couple of other cases that kind of go along with that. It's Edwards versus Arizona, which talks about the initiation test, and then Arizona versus Robertson that prohibits from interrogating a suspect about a different crime. So a lot of information, and I know that sometimes this can be a little bit confusing, but it's important that we kind of walk through a lot of this information. And here is the legal equation for a waiver following the right to remain silent. So you can kind of take a look at that there. Okay, so a little bit more on interrogations, and then we'll pretty much be wrapped up. The case of Rhode Island versus Ennis. And here, interrogation, we need to know, involves either express questioning or the functional equivalent of direct questioning. And when we talk about the right to counsel, as it relates to interrogations, this supplements the due process voluntariness and the Fifth Amendment Miranda protection. It ensures that the criminal justice process functions in a fair fashion. Under the Rothergy versus Gillespie County case, the Sixth Amendment right attaches at a criminal defendant's initial appearance before a judge. And under Brewer versus Williams, the custodial interrogation need not be conducted with questions, but can be conducted with statements, deliberately and kind of designed to elicit different types of information. A couple of other cases that are important: United States versus Henry. The Sixth Amendment provided protections to prison inmates facing trial against unknowing interrogations by undercover agents. And then in Coleman versus Wilson, the Sixth Amendment is not violated when the government, through luck or happenstance, obtains incriminating statements from the accused after the right to counsel has attached. So again, a lot of legal ease and legal information, and I know it's quick, but I want to make sure I get through everything here. And here's the legal equation as it relates to the right to counsel at interrogations. And here's an interesting case study I threw in here. It's the Russell Williams case. as it relates to a wonderful interrogation by Canadian officials on a kind of a serial murder suspect. Okay, so just briefly, I want to cover one more thing, and then we're gonna wrap it up. So remember, when you're talking about, we talked about invoking a waiver. A suspect may choose to waive their Miranda right to silence or the right to an attorney. And the Supreme Court stressed in Miranda that the government is required to meet a heavy burden in demonstrating that a person has voluntarily, knowingly, and intelligently waived their rights. The Miranda judgment states that a waiver requires an express statement and may not be presumed from the fact that an accused person remains silent. So they have to say something. And what does it mean, or what do we mean by a voluntary or knowing or intelligent waiver? Well, in the Moran versus Burbine case, the Supreme Court explained that a waiver inquiry involves basically a three-step process. The first is voluntary. Remember, we talked about voluntary. So the right must be voluntarily relinquished. It talks about knowingly and intelligent, meaning the waiver must be made with full awareness, both the nature of the right being abandoned and the consequences to that decision if you give up those rights. And then finally, the totality of the circumstances, the determination whether the waiver is voluntarily knowing and intelligent is based on that phrase, the totality of circumstances. And finally, remember, the prosecution is required to establish a knowing, voluntarily, and intelligent waiver by that predominance, if you will, of the evidence. Okay, the 51% rule. So hopefully that helped. It's a lot of legal information, I know, but we got through it quickly. So again, that's going to conclude our lecture, our second half of the lecture on Chapter 8, Interrogation and Confession. So until next time.